I'm Lisa Bernstein, the Wilson Dickinson Professor of Law at the University of Chicago. In this video, we will explore the highly romanticized story of the medieval law merchant, a tale of stateless commerce in which transnational customs and usages of trade that were widely known and generally observed among merchants played a key role in supporting long-distance trade across Europe. Trade that took place with no support from public legal systems and relied instead on private merchant courts that looked to usages to resolve disputes. The story of the law merchant has played a central role in the institutional economics literature on private ordering. It has informed the work of many of the field's founding scholars, including Douglas North, Barry Weingast, Scott Maston, Janet Thailanda, and Avner Greif. It is often treated by policymakers as a proof of concept to demonstrate the potential of private ordering to support exchange. This story has also been highly seductive to legal scholars and lawmakers. Indeed, commercial laws the world over have been inspired by the tale of the law merchant, and many of their provisions are based on the assumption that usages of trade that are coextensive with the extent of trade exist in merchant communities. The law merchant story has also influenced the way scholars and lawmakers approach a broad range of questions and issues. These range from issues dealing with economic development, to aviation law, to cyber law, to the so-called new law merchant, often invoked in transnational arbitration. Yet there is a problem, and a big problem, with using the law merchant story for these or indeed any other purpose. And the problem is very simple. The story is simply not true. It's little more than a myth that, as historian Emily Cadence has observed, simply will not die, despite the efforts of historians, including Cadence herself, Charles Donahue, John Baker, Albrecht Cordes, and others, to set the record straight through painstakingly careful historical inquiry. Indeed, the myth's allure is so strong that while proponents and codifiers of the so-called new law merchant have finally acknowledged that in all likelihood the story of the medieval law merchant is false, even with this knowledge firmly in hand, they continue to assert that it should remain the theoretical starting point for the pragmatic conception of its modern counterpart. As they explain, if we want to create a law for globalization after the nation-state, then we should look for models from before the nation-state, the Middle Ages in particular. And while they acknowledge that the story may be false and likely is false, in their view, it remains useful as a thought experiment, an imagination of how things could have been. In an effort to reorient the thinking of those who write in the areas of private ordering or commercial contracting, this video will provide a brief introduction to the evidence and the lack of evidence behind the medieval law merchant story. The next video will look at some studies that explore the existence or non-existence of unwritten trade usages in more modern commercial communities. The goal of these videos is simple. They seek to end the long and unjustified reign of what Cadence calls the tyranny of a construct, an enterprise that should open new and vastly more interesting avenues of research for institutional economists and legal scholars alike. So let's turn to the evidence from the Middle Ages. Given the widespread use of this story in both law and the social sciences, one might assume that those who peddle it have identified documents that attest to its existence. That is, documents that refer to particular transnational usages, or documents that attempt to systematize the content of sales-related usages that were said to support trade. Yet such documentary evidence does not exist. According to Charles Donahue and Emily Cadence, although there were merchant manuals describing maritime customs, there were no merchant manuals describing transnational usages. And these maritime manuals reveal that customs varied from region to region, and that many of them were deliberately imposed after the creation of written codifications, rather than adopted through the gradual evolution of custom and practice. Similarly, while there were merchant manuals designed to educate young men starting out in business, and these manuals very strongly advised learning local laws, they made no reference to learning transnational customs. In addition, while court records frequently incorporated the written decisions of merchant arbitrators, these records fail to mention specific transnational usages being used as the relevant rule of decision. Now, the work of these scholars did document some practices that might be called customs or usages, yet the practices they documented were not transnational. Rather, they were highly local, very vague, and tended to be merely procedural in content. They amounted to little more than efforts to either create shortcuts around cumbersome trial procedures or to encourage merchants to act in good faith. In the main, as Cadens carefully documents, the many scholars from numerous fields who confidently assert the law merchant existed support their claims in one of four ways. First, these scholars pointed to 16th and 17th century merchant manuals in England and other polemical discussions of the law merchant as proof. Yet these sources are not medieval. These sources do not provide evidence of actual sales customs. And the rules these sources reference do not concern the sale of goods, rather they refer only to bills of exchange. Second, these scholars cite to one another's articles which assert the law merchant existed, but none of these writings refer to any documentary evidence other than the work of other scholars, each of whom makes similar assertions. As Cadens concludes, tracing the footnotes back leads through the usual set of conclusory secondary works and primary sources taken out of context, and ends eventually with bare assertion. Third, law merchant advocates point to the adjudicatory bodies of merchant guilds who were said to apply the law merchant to resolve disputes. Yet as Cadens points out, a closer look at their operation reveals instead the parochialism of traders and their preference for their own local law. Contracts often provided for local law to apply, and the general understanding was that local law in the place the contract was made governed. Finally, scholars assert that the merchant law must have existed. Otherwise, what they took to be essentially stateless commerce could not possibly have flourished. Yet Cadens' work does more than look at the evidence. It also provides an intricate and well-documented account of how long-distance trade in the Middle Ages could have worked without any need for the mythical law merchant to have existed. Her explanation is one that should be of more interest to institutional economists and private order theorists than this myth that they have cherished for oh so long. It explores the role that numerous institutions, from travelers' inns to trading halls to brokers to notaries, and the social networks they facilitated, all played in organizing and supporting trade. Cadens also describes the role that public institutions of various types, including courts, played in supporting exchange. As she notes, merchants used, and in many towns seem to have even preferred, the public courts, both secular and ecclesiastical, to the merchant courts. Her work shows quite persuasively that the real story of trade in the Middle Ages is one of public and private institutions working in tandem with social networks underlying trade that together make it possible for commerce to flourish in the period. As her work illustrates in some detail, while there might not have been what we think of today as central national governments, this does not mean that such order that existed was spontaneous, as Bruce Benson and so many other scholars have claimed. Rather, during the Middle Ages, business could not have happened at all without the permission of local governments. Towns and guild rules controlled the manufacture of goods, down to the size, the weight, and the quality of wares, as well as the conditions under which they could be sold. Some towns also had agreements to arrest other towns' fugitive debtors. In sum, taken together, the work of these leading historians should finally put to rest once and for all the myth of the medieval law merchant. Yet ending the tyranny of this construct raises the question, where does this leave the many types of scholarship and policymaking built on this false foundation? Well, from the perspective of private order theorists and advocates, putting this myth to rest is actually very good news, as the true story of the law merchant points to a much wider variety of ways that private ordering and private order institutions can play a role in supporting exchange. Indeed, much interesting institutionally oriented work remains to be done to draw out all of the modern implications of the medieval law merchant properly understood. However, as the next video reveals, the implications of the myth's demise for legal scholars and law reformers are devastating, not empowering. For the architecture of modern commercial law falls if sales-related usages of trade do not actually exist in merchant communities.